Hi, everyone. Welcome. We are just going to wait a couple of minutes for people to log in. In the meantime, please feel free to share your name and where you're from on the chat. Hi, everyone. Welcome. Thanks so much for attending the seminar. My name is Brian. I am an immigration advisor and a caseworker at a charity called Migrants Organized. We're based in London. Part of my job is to try to get solicitors for the people that I work with. And this is Joe. Do you want to introduce yourself, Joe?
Hi, I'm Jo Wilding. I'm a researcher based at Sussex University, obsessed with legal aid and access to legal advice, particularly around immigration. And as we go through my slides, I've got links to some of the reports I've done. And I think Brian, they'll have the slides afterwards, won't they? Don't worry about scribbling those down.
Yes, we're going to send all the slides and materials after this. This session is also recorded, and all of the recordings in the seminar series is going to be published, hopefully around September to October. Right, okay. So a quick agenda for today. We're going to cover why is it important to have legal advice and representations, and Joe is going to give a briefing on the current legal aid crisis, especially in immigration. And then I will talk a little bit about how to find legal advice and representation and how to advocate against bad advice and representation. And then at the end, we'll have a bit of a Q&A section. This is a webinar function on Zoom. So you'll see there's a Q&A button at the bottom, essentially. If you have any questions, please put them on the Q&A box instead of the chat, if that's okay, because it'll make it easier for us to see what the questions are. As a lot of you hopefully know, this series is part of the Solidarity Knows No Borders Stand Up, Speak Up training series. This is the second last series, actually. So after this, there's only one more, which is going to be delivered by Zoe from ILPA on the illegal immigration bill. So do check that out and sign up if you haven't already. Right, over to you, Jo.
Thanks, Brian. So I'm going to just introduce why it's important to have legal reps and the kind of the current crisis. I know there's at least one person from Scotland on the call. Hi, welcome. Most of the crisis bit refers to England and Wales. Things are different in Scotland. I'll just talk through some of this and then Brian will take over, but there's time for questions at the end, so feel free to sort of query anything. So I suppose the first question, why is it so important to have legal reps? First of all, for the person themselves that needs it. This is really complex law in both immigration and asylum. And of course, people's immigration status affects their right to work, their access to healthcare, their benefits entitlements, rights to housing, even the right to have a bank account. So the lack of status leads to poverty, leads to homelessness, leads to potentially exploitative working conditions, and serious health consequences. So aside from the person themselves, and this is what the slide is referring to, for local authorities, those things, those issues that arise for the client, for the migrant themselves, can also trigger statutory duties, for example, under the Children Act, under the Care Act, under the Welsh or Scottish equivalents to those, around care leavers. So my most recent piece of research illustrates some of those costs for local authorities, and you can see them on the slide. It costs over 17,000 on average per household for a year for a local authority to support a family or an adult with one or more children under 18 under the Children Act. And then you can end up with one child of the family eligible for support and another child not. And so that's where they've got no recourse to public funds. So that's a huge cost for local authorities. Average of 18,500 per household if it's under the Care Act for an adult with social care needs, or again, the devolved equivalent. Average of 21,500 a year, supporting a looked after child or a care leaver if they've come out of care with no recourse to public funds, don't have their immigration status sorted, and then the local authority would still obviously be responsible for then sorting out their immigration status if possible as well. Domestic violence refuge spaces can cost £10,000 for 3 months if the person has no recourse to public funds, but the council has a duty to them. And often it's impossible to move people on from that support or move people out of destitution if they don't have recourse to public funds, if they don't have access to immigration legal advice, either for a change of conditions or to sort out their immigration status. And you see the same thing with rough sleeper funds, the Department for Levelling Up Housing and Communities funding immigration advice through rough sleeper funding. So that's money that on the face of it should come from the Ministry of Justice to pay for legal advice, but it's having to come from DLUC because there's no other way of moving someone on from the immediate emergency rough sleeping situation without sorting out their immigration status. It's also essential for asylum, obviously for asylum itself, and for the ancillary things like someone having the wrong date of birth for their child, so the child going into the wrong school year, multiple spellings of someone's name, meaning that they have multiple different NHS numbers, and local authorities and health trusts find that they can't resolve that without the threat of judicial review, which they can't realistically do without access to legal advice. So I'm going to move on to the kind of the current crisis. Brian, can you just skip to the next slide? Thank you. Oh no, that's perfect. There is a severe shortage of advice both within legal aid and in non-legal aid representation. So the research that I did in London a couple of years ago, we estimated that there were 238,000 people in London alone who are undocumented and potentially eligible for leave to remain. So there's a larger number who are undocumented, but we took from that an estimate of people potentially eligible. So the need is about 238,000 people. All of the organisations doing free advice and casework put together had a capacity for a maximum of 4,000 to 4,500 pieces of casework or representation a year outside of the realms of legal aid. Now, outside London, that's even worse. So my report for Refugee Action has a regional breakdown. Can you go to the next slide, Brian? It's much more difficult. Don't try and kind of write down or digest any of this. You've got the link to the report if you should need that information. But there's a regional breakdown. It's much more difficult to estimate the amount of casework available outside London, except that some regions have very, very few organisations. And that's what I wanted to illustrate with this table. If you look down the OISC level 3 and level 2 columns, those are the number of organisations that are eligible to do casework and representation in the various regions. So you can see, for example, Wales has very few. The Northeast has very few organisations able to do actual advice, representation and casework. You can ignore Scotland and Northern Ireland for these purposes because they have a much broader scope of legal aid. And so a lot of what's being done on level 2 and 3, or not being done on levels 2 or 3 in England and Wales, would be eligible for legal aid in Scotland and Northern Ireland. But looking then at legal aid, Brian, hop forward one, please. So this is the picture for England and Wales as a whole. And there is a deficit of at least 25,000 between the number of new applications for asylum by a main applicant, so ignoring dependents, and new legal aid matters being opened in England and Wales. So it's at least 45% deficit. It will be a bigger deficit because not every single legal aid matter start is for a new asylum case. But it's even worse than that because some legal aid providers now refuse to do appeals work because they can't afford to do it for the fee that's paid. So if people are refused asylum, even if they have a rep, they might only have, well, they have 14 days to put in an appeal, but they might now have to find a new representative as well, when there's already this massive deficit in provision, and they're going out there with an unpopular or financially unviable type of funding, looking for a new rep. Now that's this map is the picture for England and Wales overall. So the palest patches, the nearer white patches with a number in, those are the areas that have providers, legal aid provider offices, and the number represents the number of offices they had in February 2021. It's worse than that now. And some of those offices are not in fact doing and weren't doing any legal aid work. So there's lots of organisations that have a contract but aren't actually doing any work. The mid-grey areas on the map are legal aid agency areas where there's one provider, and the dark grey areas are the ones where there are no providers. So you can see quite visually, there's big gaps in provision. No providers at all in the eastern half of the East of England region and sort of on up into the East Midlands. Southwest below Bristol has just 2 people in Plymouth. Wales above the far south has nothing apart from 1 man in Wrexham, and huge chunks of the north of England have no providers. There's been provider loss since then. So we've lost 11% of the provider offices in the last year alone. There were 325 provider offices in September 2018 when the last lot of contracts were given out. So 325 when they were given out, it's now 217 offices. And that might be multiple offices of the same provider. Some providers might have only 1 office, but that's the lowest number of provider offices since immigration appeals came into the scope of legal aid and contracting started. Just go to the next slide, please, Brian. I wanted to zoom in on the southwest as an example. So these are the numbers in February 2021. It was just the one in Devon. There were 2 in Swansea, Neath Port Talbot and Swansea. There were 9 in the Cardiff, Bridgend, South Wales area, and then 9 for the south, the sort of the Bristol, city of Bristol, Gloucester, North East Somerset area. So they called, the legal aid agency called them access points for those that are not familiar. That's now down to still 2 in Swansea, 7 in the rest of Wales, and only 4 in Bristol. One of the organisations that closed in South Wales, closed quite recently, they did about 1/3 of all the matter starts in that access point in the previous year. They also did the largest number by any single office in Bristol. Another couple of organisations closed their Bristol offices. 1 closed altogether. Some of those offices then have just 1 person remaining. So there's 1 person left in one of the offices in Bristol, 1 part-time person left in one of the Cardiff offices. One of the 2 offices, the bigger one in Swansea, no longer does any appeals work. So they'll do the initial claim and they'll do public law work. They won't do any appeals because they can't afford to. There are still just the 2 people in Plymouth. So you can see there's a real loss of providers in the context that you already had a massive gap last year that will be getting bigger this year. And alongside that, you've got this shift in the geographies of need for immigration and asylum advice. So that's because we're moving away from certain dispersal areas to full dispersal of asylum applicants to all parts of the country. There's some areas seeing that for the first time, alongside contingency hotels for long-term accommodation of applicants, often in rural areas or semi-rural areas, with not only no access to legal advice, but no access to a lot of other services either. Unaccompanied children seeking asylum are now being accommodated in all local authorities except for Scilly across the whole of the UK under the National Transfer Scheme, which became mandatory in early 2022. So children being transferred all over the country. And on top of that, you have the refugee resettlement schemes, where local authorities took in resettled refugees. And again, that was the first experience a lot of local authorities had of accommodating refugees. And on top of that, the EU settlement scheme, which brought people into the realm of needing immigration advice for the first time. So immigration and asylum legal advice needs now arising throughout the UK in areas with no previous experience of it and no provision. Just go to the next slide, please, Brian. So you can see here, and don't worry again too much about the numbers, but this was a calculation, and you've got the link at the bottom of the slide. But this was a calculation that I did for my report for Refugee Action, just showing that really almost every single part of the UK, every single region has a deficit, even around eligibility just for legal aid. The only area that had at that point a small surplus and won't have that anymore because of changed dispersal patterns was London. But really there is a big deficit in many places and some deficit everywhere. And so that feeds into the question of what's the role of remote access to advice. So providers are supposed to do legal aid work face to face. They're now allowed to open up to 50% of their cases remotely. But I've already told you there's an overall massive shortage. And so the Legal Aid Agency has been asking providers to say whether they can offer services at one of these new asylum accommodation sites, the Barge off Portland, RAF Scampton in Lincolnshire, RAF Wethersfield in Essex, proposing no extra money for travel, but they'll allow a higher percentage of remote work. Now, to access advice remotely, people need a device, they need private spaces, they need a good connection, either Wi-Fi or data, but obviously data is expensive for them. They also need psychosocial support around having that appointment with their lawyers. So remote is often inappropriate from the start, but you've also got this massive deficit. So even if remote access is going to enable people to get, all it can possibly do is shuffle around that scarce capacity, not actually meet the gap. In Scotland, on the other hand, because the provision is very heavily concentrated in Glasgow, but now people are starting to be accommodated further afield, it may well be that with appropriate support, remote access could be part of the solution there. But you're still going to need all of that support, the devices, the private spaces, the Wi-Fi or data, and the psychosocial support around that. What about people traveling to lawyers? Well, in theory, lawyers are permitted to send a travel ticket in advance to the person and then to reclaim that money either after 6 months or when the case closes from the legal aid agency. But they can only reclaim it if that person turns up for the appointment and signs the legal aid forms. Likewise, if they've booked an interpreter for that person, they can only claim for that interpreter if the person actually turns up. We've still got to pay for the booking. So it's a big disincentive to taking people on. It's a big disincentive to paying for travel. And it's a big disincentive to booking an interpreter for that first hearing. So I just wanted to really briefly talk through some things that you might be able to do, depending on what each of you is kind of where each of you is positioned in the system. But if you look at my report, it's a no-brainer about local authorities funding legal advice. That can be funding an organisation or funding a specific target group. Funding advice was a financial saving for all of the local authorities which had examined it, that I spoke to. There's also savings for health trusts and hospitals, for social services. It's a bit harder to measure for police and crime commissioners, but there will be a saving in making sure that people get their immigration status and are not left sort of in the black economy. So it's definitely something to talk to local authorities about and try and sort of pull together funding from different sources within local authorities. I think it's really important that people are recording any difficulties in referring and are writing to the Legal Aid Agency, the Ministry of Justice, about that. The Lord Chancellor has a legal duty to secure the availability of legal aid in accordance with the Legal Aid Sentencing Punishment of Offenders Act, the LASPO Act. So we do need to make it his problem, because they don't actually have any research mandate to look at unmet needs. So we have to do that ourselves, unfortunately. And then the report links are in the slides. So if any of that information will help you to assess your area, or to make a case for funding or local authority funding, health trust funding, etc., you know, have a look at that. But I'm always happy to talk to anyone that wants to discuss it further. Over to you, Brian.
Right. Yeah, thanks so much, Joe. Okay, so now I'm just going to talk a little bit more about how to actually find legal advice in our presentation, and talking about quality, because obviously with this crisis going on, quality is kind of declining, basically. I'm afraid it's a bit of kind of misadvertisement, because I don't actually have the answer on how to find legal advice and representation. And at Migrants Organized, we're really struggling ourselves, even though London, as Joe said, relatively speaking, is in a much more privileged situation in terms of access to legal advice compared to other regions. It is still a big struggle, especially if we're thinking about finding someone who can actually do the work with, you know, a good quality of work for individuals, basically. So to give you a sense, last year, my colleague gathered some data in terms of our success rate for referrals to legal aid solicitors, and our rate was 0.028%, covering, I think, March to September last year. And in a lot of these cases, because we are an OIIC registered service, so we have already done kind of the legwork, basically. Usually we get advice even from counsel in terms of the case strategy. We get the documents from the Home Office. We get the exceptional case funding from the legal aid agency if required. So a lot of the legwork has been done, but it's just impossible to place someone to the legal aid provider, essentially. So just going back to the basic, to give immigration advice, you need to be accredited, and there are two main ones, essentially. One is the OISC, or the Office of the Immigration Services Commissioner. A lot of charities that provide kind of free services for migrants and asylum seekers are OISC registered, such as Migrants Organized. I've put there a link to a website, a gov.uk website, where you can actually search for all the OISC registered services in the country. And there's a way to kind of filter the search as well, so you can look up which one is free and which one is paid service. And there are 3 levels to the OISC scheme, so level 1, 2, and 3. A lot of the work, advice kind of work, you need to be at least level 2. Level 3 is for appeals work. So if the person you're working with requires someone to kind of submit application to the Home Office, for example, you need at least level 2. Legal aid providers means legal aid firms. So firms who has contract with the legal aid agency and are able to provide their service, quote unquote, for free from the perspective of the client anyway. So the client doesn't have to need to pay, but instead the work is going to be paid for by the legal aid agency. I've put there again a link of the list of all legal aid providers in the country as of July 2023. But as Joe said, a couple of them have closed down now. So I think the list is going to change a little bit. Some of legal aid providers can be charities as well. So if you think about law centers, for example, they do have a legal aid contract, but they are also charities, which means they often have kind of almost double funding to a certain extent. So they have charitable trusts providing them funding for some projects, for example, to deliver advice or representations in some cases, while at the same time, with certain cases, they can still open up a legal aid file and get also funding from the legal aid agency, which means they can have more capacity than private firms to a certain extent, although private firms can also do private work and cross-subsidize that way. It's important to bear in mind that immigration advice is regulated, and you do need to find a qualified immigration advisor to give immigration advice to yourself or the people you work with. And it's a criminal offense to give immigration advice without proper accreditation. So what's the difference between OISC and legal aid? This is just kind of like a very rough, general differences, I guess, between the OISC scheme and legal aid. And mainly I'm talking about OISC registered charity and legal aid providers. OISC services, charities, usually at the moment, I think it's more accessible to a certain extent, but they usually kind of offer less, the amount of things that they can do is also much less, essentially, compared to a full-on legal aid representation. So as I said, the OISC has 3 levels. So a lot of services, I think, are probably level 2. Is that correct, Joe? Do you know? Yeah. So they won't be able to do appeal work, for example, but they might be able to submit an application on behalf of your client, for instance. A lot of services are also level 1, so then they can only offer very basic immigration advice, things like making travel document applications, for example. A level 1 service would be able to do that. But usually, if a charity offers OISC kind of immigration advice work, they typically would also do welfare advice, though it's not always a given. But that's kind of the advantage of approaching an organization that offers OISC, basically, because they usually do, because when someone doesn't have immigration status, it's very rare that the issue that they're facing is only on immigration. They might face issues around destitution, for example, access to healthcare, access to social care, access to accommodation. And usually charities develop this kind of holistic support model where they can also get advice on these other issues. So it makes it quite handy, I would say, to link up anyone you're working with these charities in your local area. At the same time, if someone is represented by an OIC advisor, usually there's very limited access to legal expert report. So things like medical expert report, for example, or country expert report. Charities like Migrants Organized, for example, we need to kind of, even though we're OIC level 3, we need to refer to legal aid providers, because we don't have any funding to actually commission these reports for our clients. And a lot of the times these reports are quite crucial to ensure that the application is robust and strong. Legal aid providers, on the other hand, they do have access to legal aid funding, which means in theory, they can obtain the expert reports that are required, although because of difficulties and bureaucracy with the legal aid agency, sometimes this can be a challenge as well. And usually they can provide advice and representations in any matters and can kind of stick with the client throughout, essentially. So if the application is refused, they should be able to kind of help with advising on appeal, submitting the appeal notice, and then going all the way up to the court system. One of the kind of quote unquote disadvantage of legal aid provider is that for non-asylum matters, they're likely to require exceptional case funding to be in place. So I've put there a link to Public Law Project's guide on getting ECF, or exceptional case funding, in immigration cases. Essentially, under the legal aid system, anything that is outside of asylum, in generally speaking, so things like family life or private life, applications under family life or private life, you need to kind of show the legal aid agency why you require legal aid representation, and that is called exceptional case funding. So you need to make that application first, and once the legal aid agency said yes, then you can try to place the case with the legal aid provider. So in the next 2 slides, I've set out this kind of tables on kind of a bit of a guide on how to make referrals, basically, and to try to make that process as efficient as possible. So obviously you need personal details, the name, date of birth, nationality, the town the person was born in, because it's one of the questions in the legal aid form. Any reference numbers from the Home Office, contact details, full address, financial details and evidence. Obviously, if the legal aid provider and solicitor is able to take on the case, they will advise on this. But again, to make things a bit more efficient, things like asylum support letter, for example, would be really handy to prepare and to send to the solicitor, because that will immediately allow the solicitor to open the file straight away. And if the person is on benefit, a printout of the latest universal credit payment, for example, and bank statements. The stage of the immigration process, if you or the person doesn't know, that's fine as well. I think just say it. Person presents without any ID or status, for example. Otherwise, a bit of background of what has happened would be useful. So has the person, if it's an asylum seeker, has the person been substantively interviewed, for example? Have they been through the long interview, or have they been screened even? If the person already has a leave to remain, which is expiring, the date of the expiry is really important to tell to the solicitor, because then that will kind of decide the urgency of the case. Why does the person need or want to stay in the country? Again, this is just to kind of provide a bit of a background to the solicitor in terms of what kind of case it is, and whether or not, and how complex it would be essentially. You can ask the person you're working with this question, and I think a good advisor will be able to kind of formulate the case and have a sense of what the case is based on this information. So it can be as simple as, oh, the person thinks it's unsafe for them to go back. I'm scared to go back. So that might indicate it might be an asylum claim, for example, or the person here has a child. Immediately that would be probably a family case under Article 8. Vulnerabilities and needs for adjustments. This is usually quite important. Tell the solicitor what kind of adjustments the person would need. Interpreters, for example, can the person speak English? How well can the person still speak English? Can they still, read appointments on reminders on text, for example, or is it literally no English at all? Can they do remote appointments? Are they able to kind of use Zoom, or will they struggle with kind of, digital links and things like that? And lastly, ask the solicitor you're trying to refer the case to if ECF is required. Obviously, if you already know the answer, then don't bother. But if this is all, the ECF regime is quite confusing for you, then just ask the solicitor. And I've put there kind of like a template phrase that you can potentially use. The problem is some providers usually advise people that there's no legal aid when it's an ECF case. Even though actually there is legal aid, you just need to apply for it through the exceptional case funding kind of route. So it's always good to kind of just double check with the solicitor. Right, what to do in the meantime? So I think at the moment we're kind of telling our members, the people, our clients, the people we're working with, it will take at least kind of 6 months, basically, to try to find them a legal aid solicitor. Now, obviously, this is just a rough estimate, and some people do get luckier than others, and their case might be taken on very quickly. But at this point in time, honestly, it's more of a matter of luck than anything else. You just have to kind of catch the solicitor at the right time and right point in time, where they actually do have some capacity and energy to take on a new case. So in the meantime, there are some kind of helpful things that the person can potentially do, again, to just make things as efficient as possible, and to allow the solicitor to start working substantively on the case once it's taken on. So the first thing is obviously collecting documents. Any previous decisions from the Home Office or tribunals are really key. Copies of any previous applications submitted, including any evidence that have been submitted. You can obtain subject access requests. The person can obtain subject access requests from the Home Office to get their full records from the Home Office. And I will get to this next. And this is usually what a solicitor or a legal advisor would do as a first step anyway. So again, to kind of make things more efficient, they can submit the subject access request themselves. And the application is actually quite straightforward. You just have to follow the instructions on the Home Office website. One thing that I flagged there is in terms of the passport photograph and ID, because the process does ask for an ID, which a lot of migrants and asylum seekers might not have. And one way to kind of work around that is to countersign basically a passport photograph. And certain professionals are able to do this, including social workers. Remember data GDPR, of course. Records of from the Home Office can be extremely sensitive, and usually it can be, it can contain a lot of information essentially. And it would be disproportionate to request full record from the client for things like completing human rights assessment, for example, the records should be delivered to the person directly, and they can share it only with express and informed consent. And lastly, knowing, helping them know about their rights and the process of the asylum system is always helpful. I've put there a link to a website called Right to Remain, and they have a lot of really good resources for asylum seekers and migrants to understand a bit more the immigration process in the UK. Now, moving on to the quality of immigration advice and representative. Again, these are all just kind of things that I think we should be paying attention to, essentially, if we're working with someone who is assisted by an immigration solicitor or advisor. None of these kind of, again, because of the legal aid crisis, it's really difficult to expect top high-level quality that you can maybe expect from a fully private solicitor. But at the same time, hopefully these can kind of like give some kind of an indication as to when you would need to kind of step in and try to advocate for the person and maybe change the advisor. When someone is taken on by a solicitor, the initial next step will be first appointment to get initial instructions, getting the documents, as I've mentioned, so doing the subject access request, for example, and giving the client care letter and advice letter. So these are the three main first steps. And you can actually tell quite a lot the quality of representations based on these three things. If, for example, it takes a solicitor, I don't know, 4 months, say, to get the first appointment, then that's a bit of a red flag. Similarly, with getting documents, it should not take more than a few months, for example. It might take a while for the Home Office to get the subject access requests to the solicitor, but the solicitor should already start getting those documents from the clients anyway, as a first step. Communication is a very kind of strong indicator, I would say. They should update whenever there's a development, whenever they submitted something or they receive kind of important correspondence from the Home Office. I think updates every 2-3 months when there's nothing going on is quite reasonable, because as probably a lot of you here know, the Home Office also takes a very long time to make decisions. So a lot of the time, the problem is the solicitor has done everything and submitted the application, and then nothing happens for months on end or even years. And it's really hard for the client, obviously, but at the same time, there's not a lot of things that a solicitor can do. At the same time, at that stage, I think, every 3 months, a quick check-in, a quick text or an email to the client just saying that, hey, I'm still here, I'm still representing you, is actually quite important for the clients to know that there's someone who is still representing them. We work with a lot of people who actually just don't know, for example, if they still have a solicitor, just because they haven't been contacted for so long, even though nothing has happened, but it goes on for so long that they don't realize that they still have a solicitor. The solicitor or advisor should give clear advice. The client should be clear on what kind of application is being pursued. Is it Article 8, family life? Is it asylum? And there should be a clear advice letter setting this out as well. Doing the work. So this is based on our experience, basically. Sometimes rep do ask our clients, for example, to write their own witness statements or collecting their own evidence, including contacting relevant individuals, organizations. I think a lot of the times these things can be done collaboratively, and it kind of depends on how well or unwell the client is, obviously. And I think in certain situations, it does make sense for the client, for example, to start writing down their statement on their own. Or contacting people that they know or gathering some of the evidence. That's absolutely fine, but it cannot be wholly the client's responsibility to do any of these things. And it is the job of the solicitor ultimately to review them and make sure that they're up to standard. So in terms of witness statement, for example, it might make sense for the client to start a first draft of the statement, but then the solicitor should be kind of reviewing them, making sure that they kind of address the legal questions that needs to be addressed, and doesn't kind of say things that are not necessary to the Home Office. How long does it take to prepare an application? I think I get these questions a lot especially from kind of social workers who's supporting a migrant or an asylum seeker who's going through the process. I would say, again, it's really difficult to say because a lot of the time it depends on the complexity of the case, but 6 months, I think, is a good general rule of thumb. Again, it links back to the communication of the solicitor as well. If there is going to be a delay, then you would expect a good solicitor and advisor to advise the client on why there is a delay, and what steps they're taking to kind of overcome that, basically. And particularly for initial application, if the application is prepared extremely quickly, so let's say they say a month, or sometimes, you know, they might even say like 2 weeks, for example, that is actually a red flag. You know, you wouldn't expect an asylum claim, for example, to be prepared within that time frame, for that application to be properly done. Obviously, maybe it's just one solicitor who has nothing else to do and can just focus on that one application. I don't know, but it would be a red flag essentially. Most clients, I think, again, because of the crisis, would require help advocating themselves, even with their advisors. There's like a huge power imbalance between immigration clients, often with their immigration advisor. And again, because of the crisis, it's really hard sometimes to kind of deliver high quality advice and representations to everyone. So it actually really helps if you're working with someone that you also step in when you think it's appropriate and advocate on behalf of the person you're working with. Home office decision varies, but usually can only be chased after 6 months. Usually they say, you know, they will aim to kind of process things within 6 months. So then if you chase them up before 6 months, they will say, come back again after 6 months. And then you come back after 6 months, and then they will just say, oh, it's still being processed. And there's nothing there's nothing the Home Office can do. It is really difficult to challenge delay. There is no right to a timely decision in the UK, so you can't just press on the Home Office because it's been delayed for 3 years, for example. But again, you need the person should speak to their advisor and solicitor, because there might be, in certain situations, there might be ways to kind of push the Home Office. For example, if the delay is causing significant harm, mentally speaking or physically even, and there's kind of good, strong medical evidence on that, it might be possible to judicially review the delay. What about private firm? At Migrants Organized, I think we are seeing kind of like an increased number of individuals going to private firm, you know, borrowing money from friends and families, for example, to be able to get legal aid advice, to get advice and representation from a solicitor. I put there a link to the website from of a firm called Suterfic and Hartigan. They're based in London and they're excellent. They do legal aid work, but they also do private work, and they've put on their website how much they charge for private work. And I think it can be a good indication of how much roughly you would expect to pay when you're doing immigration cases privately. Again, if a private firm is charging much less, so for example, £1,000 for a complex asylum claim, that is a red flag. You know, £1,000 is obviously a lot of money for the client group if we're talking about asylum seekers with no recourse to public fund and no right to work, but it's actually not a huge amount to do a complex asylum claim. So again, it's a big red flag essentially. And remember, the fee also doesn't usually include expert reports, which might be needed. Transfer of legal aid. The legal aid agency only allows for one legal aid provider to work on one matter unless there is a breakdown of relationship or circumstances beyond the control. So for example, if the provider shut down. In other words, usually you have to kind of show that there is a breakdown of relationship, and you can submit a formal complaint, for example. If the provider hasn't done any work, you can ask them to agree that they will not charge the legal aid agency. So for example, we've worked with someone who technically had a legal aid solicitor for 2 years, but then when we investigated, they hadn't even done the subject access request, for example. So they literally haven't done anything. So obviously we assisted the client to get out of that legal aid firm to transfer them to another one. And then we asked them to agree that they will not charge the legal aid agency as they haven't done anything. And once you have that confirmation, a different legal aid provider should be able to take on the case without any issue. before initiating this process, I would say it's advisable to at least speak to an OIC advisor about the options. So go to the local charity and ask someone who knows about immigration law to kind of assess the risk of changing legal aid representation, because again, due to the crisis, it's really difficult to find a new legal aid representation. And sometimes it might be better to at least have someone on paper than having no one at all, depending on the type of case, which obviously is not supposed to be the case and how things are supposed to be done. But at the moment, it is what it is, unfortunately. Yeah, that's the end of it. Okay, we can take some questions now.
I can see there's some questions in the Q&A. So JB commented, yes, we're finding solicitors that are refusing appeals, which is really hard. And JB, you asked, are we finding people are being displaced to areas where there are no legal aid providers? Yeah, absolutely. So I tweeted the other day when the Home Office sent out an email to all providers, not the Home Office, sorry, the Legal Aid Agency sent an email to all providers saying, is anyone up for doing legal aid provision at these new accommodation sites that the Home Office has just notified us of? And that's the barge in Portland, where there is no legal advisors, no legal aid offices in the whole of Dorset, and pretty much along the south coast as far as Southampton, and then all the way to Plymouth or up to Bristol. That's from the Dorset coast, from Portland. So absolutely nothing there. RAF Wethersfield in Essex, they started putting people in this week. There are no legal aid offices in the whole of Essex. There's one that's permitted to do some outreach work from London in Essex, but that's specifically for unaccompanied children that they take on cases. And then nothing for the whole, as I said, eastern side of the East of England region. So nothing closer than London or potentially Luton. That's quite a long way from RAF Wethersfield. And then you've got RAF Scampton, which is the RAF base in Lincolnshire. And again, nothing in the whole of Lincolnshire, very little in the surrounding counties. So, you know, really large numbers of people about to be displaced to those areas. Here in Sussex, there's a little village called Upper Dicker where there's a hotel, and the hotel has dozens of people applying for asylum in it. It's got no public transport, it's got nothing in the way of services for asylum applicants, and that's being repeated up and down the country. So yeah, very much so, people being displaced to areas with no providers. Emily, you've asked, but okay, for people who are working on an initial or a fresh claim with a legal aid firm that don't do appeals, is this a legitimate reason to change solicitors? And if so, is this advisable? So kind of a big question. I think there's no roadmap to that, because the phenomenon of solicitors just saying we can't afford to do appeals is quite new. So there's not like a track record of people trying. I think it would be difficult. So going back to Brian's slide on transfer of legal aid rep, does this count as a breakdown of relationship or circumstances beyond control? Possibly not. But the other thing is, you would definitely want to find someone that was actually willing to take it on and that would do appeals, if you were otherwise happy with the firm that was putting together the fresh claim.
I think the oh, sorry.
Go on.
No, I'm to say I think the one of the big firm who say that they're not gonna do appeals do say like they might lodge the appeal. Is that correct?
I think they haven't been lodging appeals because you know, then they're sort of on record, but I don't know that they have hard and fast rules, so it's probably the best thing is to talk to the provider that you're working with if possible.
Yeah.
Um,
The
I
14 days
know
is a difficult thing, isn't it? Once that appeal is lodged, then you do have a little bit more time, I guess, to try to find someone else. And I guess the difficulty is also like the communication with the client, because a lot of them will want the representation to be, you know, as soon as possible and for something to be submitted. I've certainly worked with a lot of people who just think, you know, I will get the positive decision once something is submitted, because, you know, it can't be negative. But obviously it doesn't work that way with the Home Office.
Yeah. There's a couple of questions in the chat as well, and I'll come back to the ones in the Q&A, but yes, making the point that the lack of communication is a real trigger for clients, and what can support workers do to encourage legal reps to be more mindful of this. And I think, again, it's a real difficult question, because there's a tension around, you know, you want the legal reps to be communicating, but on the other hand, sometimes when I've interviewed legal reps, they're saying, you know, we spend 15 minutes on the phone to this person, 15 minutes on the phone to that person, and then, you know, before you know it, an hour's gone and you haven't got the work done. And there's just, you know, there's so many clients now waiting for decisions and waiting for communications. I think it is important that legal reps understand that, but I also think some of them are just run off their feet, and it's not done out of a lack of mindfulness, but just out of a lack of time. So I think that sort of support for people around, you know, understanding that these things are going to drag on and it's not them, you know, for your clients to know it's not them, it's not their fault, it's not them being singled out, but it's also not the solicitor's fault, I think is really important. So I guess a lot of the answer to your question is just, you know, explain to the clients as well that actually this is systemic and it's not personal. Yes, Mark, you're right. Particular is really in the sticks, and I think, you know, again, repeated up and down the country. Tamina, it's got all the Home Office accommodations are contracted to MERS, who also have some contracts in the north of England. Sometimes when people are placed in Home Office accommodation, they'll be relocated to England. It leaves the client in a difficult position. Yeah, exactly. Of either having to refuse accommodation to keep their solicitor, or having to find a new solicitor in England if they accept a move. And it is really problematic, because I think it just, there's this lack of kind of consistency in the system, that legal aid rules are different in Scotland from in England and Wales. If you're in England and Wales, you can't have a solicitor in Scotland, and vice versa. So really, really tricky. And I think probably at some point the only answer to this is going to be a judicial review, and sort of pulling together how that argument is put, because yeah, there's no logic to the system where you've got the two different legal aid schemes and you know, a land border and people being shifted across it. Mark, you mentioned medical evidence of the distress and delay that a delay in appeals and decisions can bring. I work for a mental health team. Usually when submitting evidence, we usually provide a medical letter with diagnosis and current circumstances. I'm never confident this carries much weight. Is this usually what's recommended? I would say, Mark, yeah, you absolutely need that medical evidence in there. And even if it feels like it doesn't carry much weight, it's definitely better to have it than not have it. So I work in the immigration law clinic in Sussex Law Centre, and we're often just, it's really helpful if you've got the medical letter and you can either send that straight to migrant help with the you know, the request to move someone, or send it to whoever they're making an application to, whether it's the Home Office or whatever. So I do think it's important. I think the lack of weight reflects more the kind of general chaos of the Home Office system, and that they're causing so many people that level of distress that often it isn't sort of exceptional. you know, that they're actually being that cruel to a really large number of people. But I think it's still important to have that medical evidence.
Yeah, I agree. I think it's worth kind of checking with the advisor as well, Mark, in terms of the questions that they need you to address in the letter. Because I have seen like some medical letters where it just kind of talks about the diagnosis, for example, and that the person is vulnerable, but that it doesn't talk about the actual impact of the delay on the person, which is actually what's needed. And it's the same with like, I don't know, any request to the Home Office, basically. It's, you know, just speak to the advisor and ask them specifically what questions they need you to address and what questions the Home Office would like answers to, essentially.
Let's go back to the Q&A. Mem, I don't know actually what the Home Office now proposes to increase the NHS surcharge to. I wonder whether that might be challengeable as well, possibly difficult, but I think that's something that should be tried because it's outrageous. I'm going to, Emily, come back to letting Brian answer your question on asylum work. But yeah, Mem, you're right. The sort of the asylum questionnaires in the so-called streamlined process, people are trying to get through those and then left in a position where other people are sort of shunted again down the waiting list. And I think a lot of people are finding they won't get an appointment until their interview is pending. And so the longer the Home Office delay in an individual case, the longer people wait to get an asylum lawyer to actually talk to them. So it's really, really difficult. And I think at least making sure that people have the information about what's going on in the system is really important. What are people doing for clients who come from Sudan and want to be reunited with family? Again, really difficult because there is exceptional case funding for refugee family reunion cases, but you'll find a lot of solicitors just don't have capacity to do them. It's a very low fee as well. If you've got young men from Sudan who want to bring their family over, the rules around refugee family reunion are very, very narrow. So it generally only applies to a spouse and children under 18. So often people are thinking, well, my family is my family, and don't realize how narrow the rules are around that. So without a specific scheme for people from Sudan, which is, you know, grossly unfair compared with, say, the Ukraine schemes, it is really difficult. But there are some specialized projects. So the Red Cross has, in some places, refugee family reunion projects. Sheffield Hallam University Law Clinic has one. So it does depend a bit where you are. Brian, over to you to repeat what asylum work people are allowed to do, but I know we're really tight for time.
Oh yeah, there is kind of like a list basically on the OIC website in terms of what level 2 and what level 3 are permitted to do. I think I don't know the answer basically, like the specific, but I can certainly send you like the link to that. Different works that are permitted on different levels is on the OIC website. Maybe I'll add that to the slides before I send them out to everyone.
So I think we have made it through all the questions, only a minute over time.
Yeah, I think so. Great. Okay, well, yeah, thanks so much, Joe, and thanks so much everyone for attending the seminar. I hope it's been useful. And yeah, we will send all the slides to you guys in a few weeks' time, and then the recording will be available hopefully in October.
Thanks so much, everybody.
Bye-bye.